specifically, I guess, the lawyer for one of the parties, determines there's a need for judicial relief. We want the judge to direct or order that something happen, and in that case, what's going to happen is a motion will be brought. I also notice in this posting later on, and I think it's, I can get there on page 3, I talk about order to show cause, and I also have attached a skeletal form of an order to show cause to the posting. What I thought I'd do, however, in this second part is talk about some experiences I've had, and any lawyer could do this, or at least any lawyer who's done any litigation, so there isn't anything special about this other than this is sort of how it's done and what has happened. And I want to talk about a motion for summary judgment, and I'm not going to refer to any specific case, but kind of a category of cases where I've done some work as a lawyer from the defense perspective. In other words, I've represented what I'm thinking of here are employers who have been sued in federal court on a claim that they either violated a employee's rights under the Americans with Disabilities Act, a federal law, or one of the Civil Rights Acts, age discrimination in employment, or there was one case I can recall, it was a claim of sexual harassment. And in those types of cases, my sense always is that there's an opportunity for me to make eventually what's known as a motion for summary judgment. And if you were to look at the handout, not the posting, but the handout, you'll see, I'm looking at it right now, that on page 29, paragraph 10, I talk about motions to dismiss, but also a motion for summary judgment. In other words, my strategy in these types of cases often has been, I'm going to try to win the case. I almost hate that term, win, but to have my client prevail without the need to go to trial. And how we're going to go about doing that is we're going to be engaging in an awful lot of what's known as discovery. More of that later in the next posting, or one of the next postings. And we're going to obtain all kinds of information from the plaintiff. And we're not only going to get, say, documentary information from the plaintiff, but we're going to have the golden opportunity to depose the plaintiff. In other words, have the plaintiff answer questions we have under oath. Obviously, the plaintiff will be in the company of his or her lawyer. But we're going to end up, we hope, with sufficient documented information, including the sworn testimony of the plaintiff, where we can, as you guys would say, literally convince the judge that under the prevailing law, there's no need to have a trial because we can establish at this point, based upon the documentation under the appropriate legal standards, that there's no question that needs to be resolved at trial, that on the state of the record we're presenting to the judge, our client should prevail. That's known as summary judgment. Obviously, it's a real big deal kind of motion. When we assemble the motion, in other words, put together the motion papers, and again, I talk about motion papers in the handout and page 28. And what we're going to have as the body of the motion, other than the notice of motion, which informs our adversary we're making a motion, we're going to have affidavits in support of the motion. And affidavits are sworn statements of fact. And we're also possibly going to have, in a summary judgment, definitely we're going to have our exhibits to the affidavits. In other words, documentation of the assertions in the affidavits. And this is, by way of exhibits, is where we're going to be able to get into the material we obtained in discovery, including the deposition or selected parts of the deposition transcript from the plaintiff. This is a real laborious process where we may be spending 30 to 40 hours, if it's a complex case, just putting together the documentation for the motion. And by the way, in federal court, and it's a good practice in state court, though it's not required, but in federal court it is required as part of our motion papers to have a memorandum of law. And you'll see that in paragraph 7 on page 28 of the handout. So we end up with a notice of motion. We have a set of supporting affidavits, and we have a memorandum of law. You'll also see this set out in the forms that I provided to you. I just don't want to track them down at this point. And then we'll serve those papers on our adversary, and oftentimes today we don't really do much by way of service except use the electronic filing available, and then that procedure sends it to our adversary because they're connected to the electronic filing. Our adversary has a chance to respond, and the response will be in the form of opposing affidavits and a memorandum of law, this is in federal court at least, in opposition to our motion. If we've done it the right way, at least the way I want to do it, I'm going to make certain I have an opportunity to reply to my adversary's opposing papers. If you will, I want to get the last written word in before we go to court. Sometimes a good reply is a very persuasive piece of work. Then we have what's known as the return date of the motion, and this is where we go to court, and it's not like a trial at all, but it's the lawyers presenting their positions. In my experience, it's been particularly in federal court, the judge, with the assistance of the judge's law clerks, is going to be fully prepared for our motion, and will probably be asking the lawyers probing questions. You know, why are you making this point? Didn't you overlook that point? How can you say that there's not a question of fact, or can you identify a question of fact that needs a trial? And that can last, that argument can last upwards to an hour if we have a summary judgment motion. The argument concludes, the judge is going to do one of two things. The judge is either going to make a decision then and there, or is likely the case in a motion for summary judgment, the judge will reserve decision because the judge wants to study the matter further, and we will be favored with a written decision from the judge. In federal court, the clerk then enters an order, because whenever there's a motion made, a judge's decision ultimately is embodied in an order. Sometimes in state court, depending upon the judge, we need to, if we prevailed on the motion, prepare a proposed order and send it to the judge for the judge's signature. So the motion practice can be, as I just indicated, very extensive. Obviously, for routine motions, or what I call housekeeping motions, which is simply arguing about a piece of discovery, we won't be spending as much time, and in a sense the outcome of the motion isn't as important. But the summary judgment motion really is significant, and to be honest, in those motions that I'm talking about in the ADA cases and the civil rights cases, if we're not able to prevail, this is on behalf of the employer, on our motion for summary judgment, we're now faced with a trial, and it may well be at that time where I'm going to be encouraging the client to consider settlement, because when we get to trial, there's so many things that can happen that there's a risk involved that it may be useful to avoid by settlement. So you'll see how significant it is if we can prevail on a summary judgment. We haven't had to pay, from the client's perspective, the plaintiff any money, and we've prevailed in the case.